They demanded she retract her legal argument, citing obscure rulings to undermine her position. Her response cited constitutional law with perfect precision, leaving the once confident judge struggling to respond. The prestigious courtroom fell silent. As Judge Richard Harmon leaned forward, microphone catching his every word, his reputation preceded him in these halls, a federal judge known for his sharp intellect, sharper tongue, and unabashedly progressive rulings. He adjusted his glasses, focusing his gaze directly at former Florida Attorney General Pam Bondi, the only conservative voice on today's panel. "You know, Ms. Bondi," he began, his voice carrying that distinctive tone, the kind that signals, "A question isn't really a question. I've always wondered how someone with your background justifies the selective enforcement of justice." The audience stirred slightly, law students exchanging glances, professors leaning forward. This wasn't the dry legal discussion they had expected. This was something else entirely, something with an edge. Judge Harmon wasn't finished. "Let's talk about your time as Attorney General, when you chose not to pursue fraud investigations against certain political allies." His emphasis on certain hung in the air, heavy with insinuation. A murmur rippled through the auditorium. The moderator, a distinguished law professor, made no move to intervene. Instead, he sat back, a subtle smile playing at his lips as if appreciating the skillful setup of a trap. Bondi sat perfectly still, her posture betraying nothing. No defensive shift, no uncomfortable fidget, just the slight raise of an eyebrow. The auditorium of Georgetown Law School was packed with aspiring attorneys, many of whom had lined up. Hours early for this panel discussion on prosecutorial discretion, marble columns flanked the ornate stage, portraits of legal giants hanging on wood-paneled walls. Watching over the proceedings with painted eyes, the smell of leather-bound books and polished wood filled the space, mixed with the subtle scent of coffee from paper cups clutched by eager students. This was meant to be an academic conversation, a thoughtful exploration of complex legal principles, but from the moment the panelists were introduced, a current of tension had been building. The moderator's introduction had set the stage. Judge Harmon, a respected judicial mind renowned for his commitment to equal justice, followed by a glowing list of his landmark decisions. For Bondi, it had been different. A brief recitation of her title, former Florida Attorney General, with a pointed mention of controversies that had nothing to do with today's topic. The imbalance wasn't subtle, nor was it meant to be. This was friendly territory for the judge, hostile ground for Bondi, and everyone in the room knew it. As Harmon continued his questioning, his confidence grew visibly, shoulders relaxed, posture more commanding. He had done this before, used these academic forums to score political points, to elevate allies and diminish opponents, all while maintaining the veneer of legal discourse. "I'm particularly interested in your decision not to investigate Trump University," he continued. Despite receiving substantial donations, the auditorium tensed even further, some students nodding along, others wide-eyed at the directness of the attack. "Makes one wonder about the integrity of our prosecutorial system, don't you think?" He wasn't asking a question, he was delivering an indictment, and the audience was the jury. A law professor in the front row leaned forward with visible interest. A journalist from a legal publication typed rapidly on her laptop, documenting every word. This moment was designed for headlines, for sound bites that would circulate through law schools and media outlets by morning. Bondi took a slow, measured breath, her hands resting calmly on the table before her. Nothing in her demeanor suggested panic or the defensive posture the judge had anticipated. When she didn't immediately respond, Harmon pressed further. "I've always believed that justice must not only be done, but be seen to be done. How do you reconcile your selective approach with that fundamental principle?" He sat back slightly, the satisfied look of a man who believes he's delivered a knockout blow. A few audience members exchanged knowing glances. This was the moment. They had come for the public reckoning, the intellectual takedown. One law student whispered to another, "She's completely out of her depth here." From the back of the auditorium, a professor nodded along with Harmon's words, his silent approval, reinforcing the consensus in the room. This was a one-sided match, and everyone knew which side would prevail. The panel's third member, a civil rights attorney with a national profile, leaned forward as if eager to pile on once Bondi inevitably stumbled. The moderator glanced at his watch, seemingly calculating how to allocate the remaining time to maximize the impact of this exchange. Bondi took another breath, straightened slightly in her chair, and reached for her water glass. The movement deliberate, almost theatrical in its calmness. The pause stretched just long enough to create a flicker of uncertainty in the previously confident room. Judge Harmon shifted slightly, perhaps expecting a defensive reaction, a flustered response, the kind that would confirm what everyone believed. Instead, when Bondi spoke, her voice was measured, steady, clear. "Judge Harmon," she began, "I appreciate your question." There was something in her tone, something unexpected. Not defensiveness, not anger, just a quiet confidence that seemed out of place for someone supposedly cornered. "That's an interesting framing you've chosen," her words careful, precise. "I notice you've presented accusations as questions. With all due respect, Your Honor." She leaned forward slightly. "Are you asking me about prosecutorial discretion, or are you making political statements?" A sharp silence fell over the room. This wasn't the response they had anticipated, not from someone supposedly outmatched. The judge blinked once, his rhythm broken. If only momentarily, his hand moved to adjust his tie. A small tell that few noticed, but Bondi did. She continued, a slight smile forming. "Let's discuss prosecutorial discretion then, since that's the topic of today's panel." Her voice took on a more professorial tone. "As State Attorney General, I made thousands of decisions based on legal, merit, evidentiary standards, and the judicious use of limited resources, principles I'm sure you apply in your own courtroom." She paused, letting the subtle reversal sink in. "In the case you're referencing, there was insufficient evidence to proceed, as 6 other state attorneys general also concluded following standard investigative protocols." Someone in the audience shifted uncomfortably. The narrative was veering off script. This wasn't how the exchange was supposed to go. The judge leaned forward again, his confidence returning. "That's a convenient explanation, considering the timing of certain contributions." His voice carried a slight edge now, the kind that betrays irritation. Bondi nodded as if considering. His point then, with the precision of a surgeon, she changed the direction entirely. "Judge, let me ask you something. Does your approach to questioning witnesses differ based on their political affiliation? Because I've reviewed several of your cases and found a curious pattern." A few gasps from the audience. The moderator straightened, suddenly alert. This wasn't just a defense, it was a counter-offensive. The judge's face remained composed, but a muscle in his jaw tightened visibly. "I don't think that's relevant to our discussion," he responded quickly. Bondi tilted her head slightly. "Isn't it, though? If we're discussing integrity in legal decisions, shouldn't we examine potential bias in all directions?" A student in the third row whispered to his neighbor, "Did she just—" The atmosphere in the room had shifted, imperceptibly at first. Then, unmistakably, what had seemed like a predetermined outcome was suddenly unpredictable. The judge glanced toward the moderator, a silent request for intervention, but Bondi continued. "In case number 453B, heard in your court last year, you dismissed evidence using discretion very similar to what you're questioning me about now. The difference being," her voice remained perfectly controlled, "is that it aligned with your personal views." The room was completely silent now, the kind of silence that feels physical, heavy with tension and surprise. The narrative had been flipped and everyone felt it. Judge Harmon's expression darkened, his hands flat against the table now. "I don't think you're in a position to question my rulings," he said, his voice colder than before. Bondi smiled, not unkindly. "With all due respect, Judge, I believe questioning authority is precisely what forums like this are designed for, aren't they?" From somewhere in the middle of the auditorium, a single clap rang out, then another and another. The moderator cleared his throat loudly, attempting to regain control, but something had fundamentally changed in those few exchanges. What happens next will reshape how everyone in this room thinks about justice, political bias, and the courage to speak truth to power. The moderator cleared his throat, shifting uncomfortably in his chair. "Let's redirect the conversation back to our outlined topics," he suggested with a forced smile. But the energy in the room had already changed. Something electric had replaced the smug certainty from moments before. Bondi sat composed, hands folded gently on the polished oak table, her eyes never leaving Judge Harmon's face. The judge adjusted his glasses, a nervous habit he'd developed. Over decades on the bench, the leather chair beneath him suddenly feeling less like a throne and more like an interrogation seat. This wasn't how the afternoon was supposed to unfold. The Georgetown Law Auditorium was a cathedral of progressive legal thought, its arched ceilings and stained glass windows casting colored light across faces of students who had come expecting a public execution, not a reversal of fortunes. The audience shifted restlessly. Notepads that had been frantically recording the judge's pointed questions now poised for something unexpected. "I'd like to continue with my point, Judge Harmon," Bondi spoke, her voice carrying effortlessly. "Without the microphone's assistance, when we discuss prosecutorial discretion, we cannot separate it from resource allocation. An Attorney General's office with limited budget must make hundreds of decisions daily about which cases merit further investigation." She reached for a leather portfolio that had sat untouched. Before her, removed a single sheet of paper, the movement deliberate, unhurried. "During my tenure, we prosecuted over 3,000 fraud cases with a conviction rate of 92%, a statistical record that speaks to our commitment to consumer protection and justice." The judge leaned forward, his expression hardening. "Yet you chose to ignore certain high-profile cases, a question designed to regain control, to put her back on defensive ground." Bondi smiled slightly, not ignoring his question but not accepting its premise either. "High profile according to whom, Judge? Media attention does not constitute legal merit, nor does political pressure from either side." She turned the paper toward him. "This is the objective assessment matrix we used for all potential fraud investigations. The same one used by the Justice Department under both Republican and Democratic administrations." A murmur rippled through the audience, law students exchanging glances. This wasn't the evasion they expected. Harmon glanced at the document, then away dismissively. "We both know resources can be found when there's political will," he countered, his voice taking on an edge. "After all, your office managed to find resources for cases that aligned with your political interests." From the front row, a professor nodded in agreement, the familiar dynamic threatening to return, but Bondi didn't take the bait. Instead, she reached for another document, placed it carefully beside the first. "This is a complete breakdown of all fraud investigations initiated during my tenure, categorized by political affiliation of targets. If there was political bias in my office, Judge, these numbers would reflect it. I invite you to examine them." Her tone wasn't challenging or defensive, just matter-of-fact, confident. Harmon didn't reach for the papers, didn't need to. The gesture itself had made her point. A young woman in the third row leaned forward with newfound interest, her expression changing from dismissal to curiosity. The judge shifted tactics. "Let's focus specifically on the Trump University case," he said. "The names of complainants, their allegations, the evidence presented to your office. certainly met the threshold for investigation. He was on familiar ground now, territory he had prepared extensively, but Bondi was already nodding. Yes, several complaints were filed, and we evaluated them using the same matrix I just showed you. She gestured to the document. The evidence presented did not meet our threshold for criminal prosecution, the same conclusion reached by Democratic AGs in multiple other states, a fact often omitted from media coverage. A student near the back straightened, Googling frantically on his phone, then whispered to his neighbor, showing them the screen, confirming her claim. Judge Harmon's expression tightened, the familiar furrow between his brows deepening. Is that your position, then, that despite the eventual civil settlement, despite the sworn testimony, despite the political contribution to your campaign, there was simply insufficient evidence? His emphasis on contribution hung in the air like an accusation. Bondi took a measured breath, her posture shifting almost imperceptibly. "Thank you, Judge, for raising that directly," she said, her voice taking on a new clarity that filled the auditorium. "Let me address the contribution question head-on, since it seems to be your primary concern, rather than the legal standards we're discussing." For the first time, someone in the audience made an audible sound, not quite a gasp, not quite a laugh, something in between, recognition that she had named the subtext of the entire exchange. Harmon's jaw tightened visibly. Bondi continued, "Without pausing, the contribution you reference was received by a political action committee 4 days before my office was notified of complaints against Trump University. Upon learning of the potential conflict, I recused myself immediately from any decision-making and assigned the assessment to career prosecutors, the very process designed to prevent bias, a process I would expect you to recognize." A history professor in the second row nodded slightly without seeming to realize it, the facts aligning with what he knew about proper procedure, but Harmon wasn't satisfied. "And yet, coincidentally, the decision aligned with your political interests," he pressed, leaning forward. "I find that timing questionable, at best." "Judge Harmon," Bondi responded, her tone changing slightly, more direct now, "I've noticed an interesting pattern in your questions. You seem to apply one standard of proof when examining my decisions and quite another when examining others. Is that your usual approach on the bench?" The moderator shifted forward, about to intervene, but Harmon raised his hand slightly, stopping the interruption. "I'm simply pointing out what appears to be a clear conflict of interest," he said firmly. Bondi nodded thoughtfully. "Conflicts of interest are indeed serious matters," she agreed. "I'd like to discuss that principle." She reached for a third document, this one thicker than the others, the gesture unhurried, deliberate. "In reviewing preparation for today's panel, I took the liberty of examining recent cases where recusal questions were raised in your court, particularly Carson versus Meridian Industries, where you declined to recuse yourself despite your spouse's investment portfolio, including significant holdings in their parent company." The silence in the auditorium was absolute. Even the soft shuffling of papers ceased. The judge's face remained impassive, but his knuckles whitened slightly where he gripped the edge of the table. "That case was reviewed by the Judicial Board and found to be within ethical boundaries," he responded, his voice lower than before. Bondi nodded. "That's correct. Just as my actions were reviewed by the Florida Ethics Commission and found to be appropriate. We both followed procedure, both were cleared by the proper authorities. The difference, Judge Harmon, is that only one of us seems to respect the outcome of proper review processes." Someone in the middle rows exhaled audibly. A professor in the back straightened, suddenly alert at the shift in dynamics. The moderator glanced nervously between the two speakers, unsure how to proceed. This wasn't the conversation they had planned, the one where an isolated conservative would be systematically dismantled by the intellectual weight of the room. Instead, they were witnessing something else entirely, a methodical, evidence-based response that was difficult to dismiss for people trained in legal reasoning. Harmon adjusted his tie, a gesture that seemed more defensive than practical. "Miss Bondi," he began, his use of the less formal address not going unnoticed by those watching closely, "these kinds of false equivalencies don't address the fundamental question." Bondi raised an eyebrow slightly. "And what is the fundamental question, Judge? I thought we were discussing prosecutorial discretion and ethics, but perhaps you have a different agenda." Her words hung in the air, the implication clear. The judge's attack wasn't about legal principles, it was about politics, and everyone in the room knew it. A young man in a crisp suit, who had been nodding along with Harmon earlier, now sat perfectly still, his expression thoughtful, questioning. The dynamic was shifting, not dramatically, not all at once, but person by person, moment by moment. As preconceptions collided with reality, Judge Harmon gathered himself, ready to launch another line of questioning, one he had prepared meticulously, but the ground beneath him no longer felt as solid as before. What he couldn't have anticipated was that Bondi had prepared not just for his questions, but for the assumptions behind them, and as he opened his mouth to speak, the atmosphere in the room seemed to hold its breath, waiting to see what would come next in this unexpected battle of legal minds where nothing was proceeding according to plan. Judge Harmon leaned forward, his frustration barely concealed beneath a thin veneer of judicial composure. "Ms. Bondi," he began, emphasizing her name with practiced authority, "I think we're getting sidetracked from the real issue at hand." The audience sensed the shift in tactics, a reset, a recalibration, another approach to regain control. "Let's be clear," he continued, "the question isn't about procedure, it's about judgment, about whether certain decisions reflect a commitment to equal justice or political convenience." His voice had found its rhythm again, the cadence of the courtroom where he had spent decades commanding attention. Behind him, through the tall windows, afternoon sunlight cast long shadows across the polished floor of Georgetown Law School, highlighting dust particles floating in the air like suspended moments of tension. Bondi took a small sip of water, allowing his words to settle, her face betraying nothing, not agreement, not offense, just patient attentiveness that somehow made several students shift uncomfortably in their seats. "I appreciate your clarification, Judge," she finally responded. "I agree this is fundamentally about judgment." Her calm was unsettling to those who had expected defensiveness. But judgment cuts both ways, doesn't it? The selective application of scrutiny is as concerning as the selective application of justice. A soft murmur rippled through the audience. Professors exchanging glances, recognizing the subtle but effective counter. Harmon's jaw tightened almost imperceptibly. "I'm not the one being questioned here," he stated firmly. "But in fact, you are," Bondi replied simply. "That's the nature of intellectual discourse, each of us questioning and being questioned in turn. Or did you expect something different today?" Someone near the middle of the auditorium coughed to cover what might have been a laugh. The third panelist, a civil rights attorney who had been waiting for his moment to speak, glanced at his notes, then closed his portfolio. Sensing that his prepared talking points might no longer fit the unfolding dynamic, the moderator leaned toward his microphone. "Perhaps we should move to our next topic," he suggested hopefully, "legal standards for corruption investigations." Harmon waved him off. "I'd like to finish this discussion," he insisted, his voice carrying an edge now, the kind that had silenced many attorneys in his courtroom over the years. "Ms. Bondi, you very skillfully avoided addressing the central criticism of your tenure as Attorney General, the appearance that your office protected political allies from scrutiny. This approach seemed to work. Heads nodded throughout the audience. A return to familiar territory, solid ground for the judge. Bondi smiled slightly, an expression that reached her eyes, genuine but not unkind. Judge Harmon, I haven't avoided anything. I've provided documentation, evidence, and context for every decision you've questioned, while you've offered opinions, media narratives, and selective framing. She gestured to the papers still sitting between them. The facts are right here, should you choose to examine them. A student in the front row looked up from her laptop, where she'd been furiously taking notes, her expression changing from certainty to curiosity. Harmon bristled visibly now. Facts can be arranged to support any narrative, he countered, his voice sharper, a tactic that had intimidated countless witnesses. Bondi nodded in agreement. Precisely. My point, Judge, which is why we rely on objective standards, consistent application of principles, and transparent review processes rather than cherry-picked examples and emotional appeals. From the back of the room, a distinguished professor of legal ethics leaned forward in his seat. Watching with growing interest, what had begun as political theatre was transforming into something more substantive, a genuine examination of how justice functions beyond partisan framing. Harmon sensed the shift in the room, the audience. No longer solidly aligned with his line of questioning, he needed to regain momentum. Let's take a specific example then, he said, his tone authoritative once more. Your office declined to join a multi-state investigation into mortgage fraud that affected thousands of Florida homeowners, despite clear evidence of wrongdoing. How do you justify that to the people who lost everything? His words hung in the air, heavy with implied moral weight. A student in the third row nodded vigorously. This was the kind of direct challenge they had come to witness. Bondi didn't rush to respond. Instead, she opened her portfolio again, removed several stapled pages, and placed them carefully on the table. This is the complete record of our mortgage fraud actions during my tenure, she said calmly. We prosecuted 17 major banks and lenders, secured over $2 billion in relief for Florida homeowners, established the most aggressive mortgage fraud task force in the state's history, and achieved the third highest recovery rate nationwide. She pushed the document toward him, not aggressively but matter-of-factly. The specific investigation you're referencing was declined because we had already initiated our own more comprehensive approach with higher recovery targets. The results speak for themselves. A journalist from a legal publication was typing rapidly now, fact-checking her claims in real time, finding them accurate. Harmon didn't touch the document, his dismissal of evidence becoming a pattern that wasn't lost on the observant crowd of law students and professors. Yet you allowed certain institutions to escape accountability, he pressed, doubling down, particularly those with connections to state government. Now Bondi's expression changed slightly, not to anger but to something more focused, more precise. Judge Harmon, she began, her voice taking on a new clarity. I've noticed throughout this exchange that when presented with evidence that contradicts your narrative, you simply change the accusation without acknowledging the response. Is that how you conduct proceedings in your courtroom? The question hung in the air, direct but not disrespectful, challenging the very foundation of his judicial approach. Several professors straightened in their seats, recognizing the skillful redirection from defensive answering to fundamental questioning. Harmon's face flushed slightly, the first visible crack in his composed facade. That's an inappropriate characterization, he responded, his volume rising. Slightly. I'm asking legitimate questions about serious issues of public concern, Bondi nodded. I agree these are serious issues, which is why they deserve serious analysis, not political sound bites. She gestured to the documents between them. I've provided comprehensive evidence of how we approach these cases, evidence that directly contradicts your characterization, yet you haven't engaged with a single factual point. A senior professor in the second row removed his glasses thoughtfully, watching the exchange with newfound interest. The moderator shifted uncomfortably, sensing control of the panel slipping further away from the planned narrative. Harmon leaned back slightly, adopting a different posture, one of academic skepticism. "Well, Ms. Bondi," he said with an air of finality, "we simply have different interpretations of your record, a diplomatic retreat, an attempt to end the exchange with his authority intact." But Bondi wasn't finished. "It's not about interpretation, Judge," she responded, her voice measured but firm. "It's about facts, evidence, and legal standards, the very foundations of our justice system." The audience was completely silent now, hanging on each word of the exchange, recognizing that something unexpected was unfolding. A young law student whispered to her neighbor, "She's actually winning this." Harmon straightened his tie, a gesture that several students who had interned in his chambers recognized as a sign of frustration. "Ms. Bondi, I think you're missing the larger point," he began, his tone deliberately patronizing. "The perception of justice is as important as justice itself. Your office created a perception problem, regardless of what your carefully prepared documents might suggest." The civil rights attorney shifted in his seat, glancing at the moderator, silently questioning whether to intervene, but Bondi was already responding. "Perception, Judge Harmon, is often shaped by incomplete information, selective framing, and yes, political agendas." She gestured toward the audience. "These future attorneys deserve better than that. They deserve to understand how justice actually works, not how political narratives portray it." A student who had arrived wearing a button supporting progressive causes found himself nodding in agreement. Surprised by his own reaction, the judge's expression darkened, a look familiar to attorneys who had challenged him in court. "Well, I think we've exhausted this topic," he said with finality, signaling to the moderator, an expression that clearly communicated it was time to move on. But as the moderator prepared to speak, Bondi added one final thought. "I hope we have exhausted it, Judge," she said, her voice clear and steady, "because these students deserve to see that justice isn't about partisan framing. It's about consistent application of principles, regardless of political convenience." A few students began to nod. Others sat forward, their expressions changing from dismissal to consideration as the moderator finally regained control, announcing a shift to the next topic. The dynamic in the room had fundamentally changed. What began as a planned takedown had transformed into something else entirely. A moment of unexpected substance where preconceptions collided with reality, and the audience was left to reconsider not just the specifics of the debate, but their own assumptions about how truth reveals itself when challenged in the public square. The moderator cleared his throat twice, shuffling papers nervously before him. "Let's move to our next topic," he announced. "The role of personal ethics in public service. Judge Harmon, perhaps you can start us off?" The relief in his voice was palpable, an attempt to reset the conversation to more familiar territory. Judge Harmon straightened, adopting his most professorial posture, hands clasped before him on the table. "Personal ethics in public service is fundamental," he began, his voice finding its confident rhythm. "Those who serve must hold themselves to the highest possible standard, above reproach, above suspicion, even above the appearance of impropriety." His words flowed easily now, practiced and polished from dozens of lectures. Commencement speeches, judicial conferences, this was comfortable ground, a moral high road where few could challenge him. The audience settled, some students resuming their note-taking, others watching with renewed interest, wondering if the unexpected dynamic from moments before would continue. "Ethics isn't just about following rules," Harmon continued, building momentum. "It's about recognizing that public trust is both precious and fragile. We who serve in government must understand that our actions are judged not just by legal standards, but by the public's expectation of integrity." The civil rights attorney nodded along, finding little to disagree with in these abstract principles, while Bondi sat quietly, attentive, her expression revealing nothing as Harmon continued his discourse. "When I consider ethical obligations in my courtroom," he said, I ask myself not just, is this legal, but is this right? Does this uphold the public's faith in our institutions? He glanced toward Bondi, the implication clear though unstated, a contrast he wanted the audience to notice. A young woman in the second row, who had been skeptical of Bondi at first, found herself watching the former Attorney General with new curiosity, noticing her calm attentiveness, even when being implicitly criticized. The judge continued, his voice rising slightly with practiced cadence. In today's political climate, we see too many examples of technical compliance with laws while violating their spirit, of parsing words, finding loopholes, explaining away. Actions that deep down, we know betray public expectations. Several professors nodded, the sentiment unobjectionable in its generality. Harmon was building toward something, his rhythm the familiar approach of setting up abstract principles before applying them to specific targets. I believe, he said with judicial gravity, that we must hold ourselves accountable, not just to the letter of ethics laws, but to their fundamental purpose, which is maintaining the sacred trust between government and its citizens. He paused. For effect, a technique refined over decades, then turned directly to Bondi. Wouldn't you agree, Ms. Bondi? The question wasn't really a question. It was a setup, a trap designed to force either agreement that could later be used against her or disagreement that would seem indefensible. The audience leaned forward slightly, sensing the strategic maneuver, waiting for her response, but Bondi smiled slightly, meeting his gaze directly. Absolutely, Judge Harmon, she said without hesitation. I couldn't agree more with the principles you've outlined. Harmon blinked, not expecting such ready agreement. Bondi continued, her voice clear and measured. In fact, your description of ethical standards aligns perfectly with how I approached my office, which is why we established the most transparent processes in Florida's history. She reached for her portfolio again, producing another document, this one bearing an official seal. We created Florida's first comprehensive ethics manual for prosecutors, she explained, which went beyond statutory requirements to address exactly what you've described, the space between legal compliance and public expectations. A law professor, in the front row, leaned forward with interest, recognizing the manual she referenced, one he had actually used in his ethics class. Harmon hadn't anticipated this turn. He had expected either defensiveness or vague platitudes about good intentions, not concrete examples of ethical leadership. I'm familiar with your manual, he said dismissively, but manuals and actual practice can be quite different things. Bondi nodded again in apparent agreement. You're absolutely right, Judge. That's why we didn't just write policies. We implemented accountability measures, public reporting requirements, and independent review processes. She gestured to another document. The results of our annual ethics audit conducted by an independent committee that included members from both political parties. She turned to face the audience directly, addressing the students now. As future attorneys, you'll discover that ethics isn't about declaring principles. It's about building systems that ensure those principles are followed, even when they're inconvenient, especially when they're inconvenient. Her words landed with unexpected weight, practical wisdom rather than political positioning. Harmon shifted strategies again. Well, let's discuss a specific example then, he suggested, his tone sharpening. Your decision to appear at a Trump property for an official fundraiser while your office was considering fraud complaints against Trump-related businesses. Wouldn't ethical leadership have suggested avoiding even the appearance of such connections? The question was direct, pointed, designed to corner her into either admitting poor judgment or making excuses. Several audience members nodded. This seemed like checkmate. Bondi didn't hesitate. That's an excellent case study in ethics, Judge, she replied, her tone conversational rather than defensive. When that invitation was extended, I consulted with our ethics officer immediately. She gestured to a document already on the table. This memo details the analysis we conducted, the firewall procedures we implemented, and the recusal protocols we established precisely to address appearance concerns. While I was speaking at the event in question, the fraud assessment was being conducted by career prosecutors with no knowledge of my schedule or appearances, and no reporting relationship to me. Harmon frowned slightly. But surely you recognize that the public might view such connections as inappropriate, regardless of internal procedures. A valid point, Bondi acknowledged. Public perception matters greatly, which is why we issued this public statement. She produced another document detailing the specific measures taken to ensure independent review. We didn't just implement safeguards, we communicated them transparently so the public could understand how their interests were being protected. A student who had been skeptical before found himself impressed despite his political differences with her thorough preparation and substantive responses. Harmon sensed his advantage slipping and tried another approach. "Ms. Bondi," he said, his tone becoming almost paternal, "these are all very impressive documents, but they feel rather like retrospective justifications rather than proactive ethical leadership. Wouldn't true ethical leadership have simply avoided such situations entirely?" The question hung in the air, seemingly reasonable, yet carrying an impossible standard, as any public figure would recognize. Bondi considered this thoughtfully before responding. "Judge Harmon," she began, her voice taking on a new dimension, "ethics isn't about avoiding every situation that could be misperceived. It's about establishing systems that ensure integrity regardless of circumstances." She leaned forward slightly. "If we followed the standard you're suggesting, no prosecutor could ever participate in political events, fundraisers, civic organizations, or community gatherings where they might encounter people connected to matters before their office." A professor of legal ethics nodded, recognizing the practical reality she described. "The standard you're proposing, Judge, would effectively require all prosecutors to live in isolation from the communities they serve, which would create its own ethical problems of disconnection and insularity. Wouldn't you agree?" Harmon's expression tightened. "I'm not suggesting isolation, merely appropriate boundaries." Bondi nodded. "That's precisely what we established. Appropriate boundaries, documented safeguards, and transparent processes. Rather than the appearance of impropriety, we created actual procedural integrity." She turned to the students again. "As future attorneys, you'll face these challenges constantly. The question isn't whether you'll encounter potential conflicts of interest, but how you'll manage them with integrity." Her approach had shifted subtly from defending her record to teaching from it, sharing practical wisdom rather than political talking points. Judge Harmon recognized the shift, sensed the audience's changing perception, and decided to reclaim the high ground. "Well," he said with judicial authority, "I maintain that higher standards would better serve public confidence, a statement few could disagree with in principle." Bondi smiled with genuine warmth. "I agree completely, Judge. Higher standards are essential, which is why I'm so proud of the reforms we implemented, the independent audits we established, and the transparency measures we created. In many cases, exceeding federal requirements and setting new benchmarks for state offices." Her response left no room for further attack, without seeming unreasonable. The audience could sense it too. The dynamic had shifted completely now. What began as an anticipated takedown had transformed into something far more substantive and unexpected. A demonstration not of political theater, but of how ethical leadership actually functions in the complex reality of public service. Beyond the simplistic narratives that so often define it, the tension in the auditorium shifted like weather changing before a storm. Judge Harmon's face remained composed, but those who knew him well could see the subtle signs of frustration, the slight tightening around his eyes, the barely perceptible clenching of his jaw. This was not proceeding as planned. The moderator, glanced at his notes nervously. "Let's open the discussion to our audience," he suggested finally. "We have time for a few questions." Hands shot up immediately throughout the room. The moderator pointed to a young woman in the fourth row wearing a Georgetown law sweatshirt, her expression eager, confident. "My question is for Judge Harmon," she began, her voice carrying clearly through the space. "You've spoken about the importance of impartiality in our justice system. How do you ensure your own political beliefs don't influence your judicial decisions, especially in politically charged cases?" The question wasn't hostile, but it wasn't softball either. Several professors exchanged glances, recognizing that the dynamic in the room had fundamentally shifted. Harmon straightened slightly. "That's an excellent question," he began, his voice finding its authoritative rhythm. "Impartiality is indeed the cornerstone of judicial ethics. I maintain separation between my personal views and my legal judgments through rigorous application of precedent and statutory interpretation." He continued for several minutes, explaining judicial philosophy, citing renowned legal scholars, his answer polished, practiced, the kind that normally satisfied such inquiries. But when he finished, the student remained standing. "Judge Harmon," she pressed with respectful persistence, "you ruled in the Davidson case last year that evidence of racial bias was inadmissible, citing procedural grounds. Yet in the similar Peterson case, you admitted comparable evidence, the key difference appearing to be the political implications of each case. How do you reconcile those decisions with the impartiality you've described?" A murmur rippled through the audience. This wasn't the expected deference from a student to a federal judge. Something had changed in the atmosphere, giving permission for more substantive challenges. Harmon's expression tightened visibly now. "Those cases had significant procedural differences," he responded, his tone cooling. "The evidence standards were distinct, as explained in my written opinions. I suggest reviewing them more carefully." The dismissal was clear, intended to end the exchange, but the damage was done. The student sat down, but the impression lingered. The moderator quickly pointed to another hand, a middle-aged man in a tailored suit standing near the back. "My question is for Ms. Bondi," he said, his tone professionally neutral. "You've presented impressive documentation of your office's approach to ethics and procedures, but critics would say this focus on process misses the larger question of judgment. Shouldn't a state attorney general simply avoid any connection to individuals or organizations under potential investigation, regardless of procedural safeguards?" The question was challenging but fair, asked without the hostility that had characterized earlier portions of the discussion. Bondi nodded thoughtfully. "That's an important question," she began, her voice clear and measured. "In an ideal world, yes, complete separation would be preferable, but the reality of public service is more complex." She leaned forward slightly, engaging directly with the questioner. "As Attorney General, I oversaw an office with jurisdiction over every business, political organization, and institution in Florida. The practical reality is that complete isolation is neither possible nor desirable. The crucial question isn't whether connections exist, but how they're managed with integrity." She gestured to the document still on the table. "That's why we created these systems, not as bureaucratic shields, but as practical safeguards that ensured decisions were made on legal merit alone, regardless of political considerations." The questioner nodded appreciatively and followed up. "But doesn't that approach risk prioritizing technical compliance over the spirit of ethical leadership?" Bondi smiled, not defensively but thoughtfully. "It would if we had stopped at compliance, but we didn't. We established independent review panels with bipartisan membership, public reporting requirements, and transparency measures that exceeded anything required by law." She looked around the room, making eye contact with various students. Technical compliance is the floor, not the ceiling of ethical leadership, but neither is ethical leadership about appearances. It's about creating systems that ensure integrity, even when no one is watching. The questioner nodded again, seeming satisfied, and took his seat. Judge Harmon shifted in his chair, visibly uncomfortable with Bondi's growing rapport with the audience. The moderator called on a young man in the front row wearing a bow tie, his question directed at both panelists. In our current political climate, where everything is viewed through partisan lenses, how can legal professionals maintain credibility when their decisions will inevitably be criticized as politically motivated, regardless of merit? The question cut to the heart of modern challenges facing the legal profession. Judge Harmon responded first. "We must simply continue applying the law faithfully," he said with judicial certainty, "and trust that over time the correctness of our decisions will become apparent." The answer was brief, principled, but somehow lacking in practical insight. Bondi considered the question carefully before responding. "That's perhaps the greatest challenge facing our profession today," she acknowledged, "the presumption that every legal decision must have a political motivation." She leaned forward, engaging directly with the student who had asked. "In my experience, the best approach is radical transparency, not just about decisions but about process. When I took office, we began publishing the complete decision matrices for major cases, showing exactly how conclusions were reached, what evidence was considered, what standards were applied." She gestured to encompass the room. "As future attorneys, you'll face this challenge constantly. People will question your motives, assign political intentions to legal decisions. The only effective response is to make your process so transparent that reasonable observers, regardless of political affiliation, can see how you arrived at your conclusion, even if they disagree with it." The student nodded, writing something in his notebook, clearly engaged with her practical approach. Judge Harmon interjected, "Transparency has limits, though," he noted, his tone professorial. "Sometimes legal processes require confidentiality." "A valid point," Bondi acknowledged. "Absolutely, Judge. You're correct. Confidentiality is sometimes legally required, which is why we created sealed transparency protocols with independent reviewers who could verify the integrity of processes without compromising necessary confidentiality." Several professors nodded, recognizing the sophisticated approach she was describing, one that acknowledged real-world complexities rather than retreating to abstract principles. The moderator called on a final questioner, an older woman near the middle of the auditorium, her expression thoughtful, serious. "Miss Bondi," she began, "throughout this discussion, you've demonstrated remarkable composure and substantive knowledge, despite what many would characterize as hostile questioning. What advice would you give to law students, particularly young women, about maintaining their professional dignity when faced with similar challenges?" The question shifted the frame entirely, acknowledging what everyone in the room had been observing, but not naming. Bondi took a moment before responding, her expression softening slightly. "Never let anyone else define the conversation," she said finally. "When you know your facts, when you've done your work, when you've followed proper procedures, you have nothing to fear from questioning, no matter how hostile it might seem." She looked around the room, making eye contact with female students, particularly those who had seemed initially skeptical. "Prepare so thoroughly that you can respond with substance rather than emotion, with evidence rather than defensiveness. Because ultimately, the strongest position isn't the loudest or most aggressive, it's the one best supported by facts, not just your facts, but your entire approach to gathering, analyzing, and presenting them." Several students were nodding, now taking notes with renewed intensity. Judge Harmon shifted uncomfortably. recognizing that the final question had effectively reframed the entire exchange, not as his examination of Bondi, but as her masterclass in professional integrity. The moderator checked his watch. "We have time for one more question," he announced, seeming reluctant to extend what had become an increasingly uncomfortable session for those who had planned it. A hand raised from the very back of the auditorium, belonging to a distinguished professor emeritus known for his non-partisan legal scholarship. "This question is for Judge Harmon," he said, his voice carrying the weight of decades of respected legal analysis. "Throughout this discussion, you've questioned Ms. Bondi's approach to prosecutorial discretion, suggesting that her decisions may have been influenced by political considerations." The room fell completely silent. The professor continued, "Yet when presented with documentation of consistent standards, independent review, and transparent processes, you've dismissed this evidence without substantive engagement." His question, when it came, landed with the quiet force of a gavel. Does this selective approach to evidence not demonstrate precisely the kind of bias you have suggested existed in her office? The silence that followed was absolute. Judge Harmon's face flushed visibly, for the first time completely losing his judicial composure. "I don't think that characterization is fair," he managed finally, his voice strained. The moderator jumped in quickly. "I'm afraid we're out of time," he announced with poorly concealed relief. "Please join me in thanking our distinguished panelists for this lively discussion." Applause filled the auditorium, but it wasn't the polite acknowledgement that normally concluded such events. It was something else entirely, something that carried meaning. As students stood gathering their materials, many approached the stage, forming a line not around Judge Harmon, as would have been expected, but around Pam Bondi, seeking handshakes, additional questions, business cards, what had been intended. As a public criticism had transformed into something entirely different, a demonstration not of political bias, but of professional integrity, a lesson far more valuable than the one that had been planned. As the formal panel concluded, the real conversation was just beginning. Judge Harmon stood quickly, gathering his notes with practiced efficiency, a tight smile fixed on his face as he nodded to faculty members who approached with obligatory deference, but his eyes tracked the crowd forming around Bondi, a development he hadn't anticipated. The Georgetown Law Auditorium normally emptied quickly after events, students rushing to their next class, professors hurrying to office hours. But today, something different was happening. People lingered, clustered in small groups, discussing not just the content of the panel, but its unexpected dynamics, the way presumptions had been challenged, the way evidence had prevailed over narrative. A young woman approached Bondi cautiously. "Excuse me, Ms. Bondi," she began, her voice hesitant but determined. "I came here today with certain expectations," she admitted. "I didn't think I'd agree with you." Bondi smiled warmly, waiting for her to continue. The student took a breath. "I'm still not sure I do on many policy issues," she clarified, "but the way you handled yourself, the way you focused on substance, not politics, it made me rethink some assumptions." Bondi reached out, touching her arm lightly. "Thank you for telling me that," she said with genuine appreciation. "Our profession needs more people willing to reconsider initial judgments when presented with new information." The student straightened, slightly bolstered by the acknowledgement. "Do you have any advice for someone considering a career in public service, especially in today's political climate?" Bondi considered this thoughtfully. "Know your principles before you need them," she answered. "Follow processes, not personalities, and always be better prepared than anyone else in the room." From across the auditorium, Judge Harmon watched the exchange, his expression unreadable as a senior faculty member engaged him in conversation about an upcoming law review article. But his attention remained divided, focused on the unexpected aftermath of what should have been a simple takedown. Near the door, a group of students huddled around their phones, sharing video clips already circulating on social media. "Did you see his face when she pulled out that ethics manual?" one whispered, shaking his head in amazement. Another student nodded, checking Twitter. "It's already trending in DC legal circles." Someone posted the clip with the caption, "When preparation meets presumption." The moderator approached Bondi, extending his hand with newfound respect. "That was certainly a more robust discussion than we anticipated," he acknowledged, his diplomatic phrasing barely concealing his recognition of what had occurred. Bondi shook his hand warmly. "Thank you for the opportunity. I believe students benefit from seeing substantive debate rather than political theater." Her words carried no accusation, but the implication was clear, as was his slight nod of acknowledgement. Across the room, two professors, one constitutional law, one legal ethics, conferred in hushed tones. "I haven't seen Harmon handled like that in 20 years of panels," the constitutional scholar whispered. His colleague nodded thoughtfully. "More importantly, did you notice how she did it? With evidence, not rhetoric, facts, not personal attacks." The room continued to buzz with conversation as security began gently ushering people toward the exits. Judge Harmon stood near the stage, now surrounded by a smaller group, mostly faculty and administrators. His voice carrying just slightly, "An impressive performance," he remarked dismissively, though of course prepared statements are one thing, real-world decisions another. A dean nodded politely, but his eyes reflected something else, a recognition that the dismissal rang hollow after what they had all witnessed. An administrative assistant approached Bondi with professional courtesy. "There are several reporters outside requesting comments," she informed her, "and the dean would like to know if you'd be willing to meet with some students in the moot courtroom for additional questions." Bondi checked her watch. Considering her schedule, "I'd be happy to speak with students," she replied, "but we should invite Judge Harmon to join us as well." The assistant glanced toward the judge, who was already heading toward a side exit. "I believe he has another commitment," she said diplomatically. Bondi nodded, understanding the unspoken reality. Near the main entrance, a journalist from a prominent legal publication was interviewing a group of students. "How would you characterize today's discussion?" she asked, notebook poised for their responses. A student wearing a Georgetown Law sweatshirt considered the question carefully. "I came expecting a political debate," she admitted, "but what we got instead was a master class in professional integrity." Her classmates nodded in agreement. Another student jumped in. "I think what impressed me most wasn't just her knowledge but her approach. She didn't try to win by attacking. She just systematically presented evidence in a way that couldn't be dismissed." The journalist made notes rapidly, sensing a different story emerging than the one she had anticipated. Inside the auditorium, Bondi gathered her documents, carefully returning them to her portfolio. When a senior professor approached, "Ms. Bondi," he began, his tone measured, "I want you to know that while I likely disagree with many of your policy positions, I found your approach today exemplary. I hope our students were paying attention to how you elevated substance over spectacle." Bondi smiled with genuine appreciation. "Thank you, Professor. That means a great deal." He hesitated, then added, "I'm curious, though. You must have anticipated the nature of today's questioning. You came remarkably prepared." Bondi nodded. "Yes, I did my homework. I reviewed Judge Harmon's prior panels, his judicial opinions, his public statements. I identified likely lines of questioning and prepared comprehensive responses." The professor raised an eyebrow. "Most guests don't put in that level of preparation, especially for what's essentially a hostile environment." Bondi considered this. Thoughtfully, "In my experience, Professor, thorough preparation isn't just about having answers. It's about respect for the process, for the institution, and for the students who came here to learn something of substance." The professor nodded, appreciation in his eyes, as Bondi excused herself to meet with waiting students. Meanwhile, at the side exit, Judge Harmon encountered a former clerk, now a practicing attorney, who had attended the panel. "Judge," the young man greeted him with the deference of a former subordinate, "that was certainly an unexpected discussion." Harmon straightened his tie, a gesture of composure recovery. "She was well prepared," he acknowledged curtly, "though, of course, cherry-picked examples don't tell the complete story." The former clerk nodded automatically, but something in his expression suggested he wasn't entirely convinced. As the judge pushed through the exit door into the afternoon sunlight, seeking the privacy of his waiting car, inside the building, the conversations continued. A group of first-year students huddled around a laptop, rewatching key moments from the panel, seeing the dynamic unfold again. "Did you notice Bondi never got defensive?" one observed, pointing to the screen. "Even when the questions were clearly designed to provoke an emotional response." His friend nodded thoughtfully. "It's like she was playing an entirely different game, not trying to score political points, just methodically presenting evidence while Harmon was trying to create gotcha moments." Near the entrance to the moot courtroom, a line of students had already formed, waiting for the impromptu Q&A session with Bondi. A teaching assistant overseeing the queue spoke quietly with a colleague. "Did you notice how the whole tone of the room changed after that first exchange?" she asked. Her colleague nodded. "Absolutely, it was like watching someone defuse a bomb with perfect precision, recognizing exactly which wires to cut." Outside the building, news crews had assembled, alerted to the unexpected storyline developing from what should have been a routine academic panel. Producers checking social media feeds, where clips were already gaining traction, prompting commentary from legal experts and political analysts alike, most noting the same remarkable feature, how a political confrontation had transformed into something more substantive, more significant than partisan points. As the afternoon light began to fade, casting long shadows across Georgetown's campus, the impact of the day's events was still unfolding, not in dramatic declarations or headlines, but in small conversations between students, in text messages, between colleagues, in quiet reconsiderations of assumptions. This wasn't just about politics or personalities, it was about something more fundamental, the triumph of substance over spectacle, of preparation over presumption, of evidence over accusation, lessons that would linger long after the specific details of the panel were forgotten, as one professor remarked to another while watching students eagerly file into the impromptu session with Bondi. Today, these students learned more about legal practice and professional integrity than a semester of lectures could teach them. Sometimes the most powerful lessons are the ones we least expect from the most unexpected teachers. The media aftermath began almost immediately as Pam Bondi exited Georgetown Law School, evening shadows stretching across the campus, students still buzzing with animated conversations about what they had witnessed. The first clip hit Twitter at 5:47 p.m., posted by a second-year law student with the caption, "Watch this liberal judge get completely schooled on prosecutorial ethics." Within minutes, it had hundreds of retweets, by midnight thousands. The major networks hadn't planned to cover the panel, a routine academic discussion, hardly newsworthy under normal circumstances. But as clips continued to spread overnight, producers arriving for morning shifts found themselves scrambling to catch up. On the unexpected viral moment, in the green room of a cable news studio, a legal analyst watched the footage again, shaking his head in disbelief. "I've known Richard Harmon for 15 years, he muttered to a producer standing nearby. "I've never seen him handled like that. Never seen him so thoroughly unprepared for a substantive challenge." The producer nodded. "That's why we're leading with it. The switchboard's been lighting up since dawn." Judge Harmon, meanwhile, had cancelled his morning appearances, citing a schedule conflict, his office declining all requests for comment on the previous day's panel. The contrast wasn't lost on media observers, who noted that Bondi had already appeared. on 2 morning shows, not to spike the football or claim victory, but to discuss the substantive legal issues that had been raised during the panel, her composure extending beyond the event itself. The Washington Post Legal Affairs blog published an analysis by mid-morning, Beyond Politics, When Substance Prevails Over Spectacle, examining not just the content of the exchange, but its broader implications for legal discourse in an era of performative confrontation. By lunchtime, CNN had assembled a panel of legal experts to break down the exchange, the discussion quickly moving beyond partisan talking points to something more nuanced. What we witnessed, Professor Janet Michaels began, was the difference between preparation and presumption, between evidence and assertion, a distinction that often gets lost in our political discourse. Her colleague nodded thoughtfully. Bondi came armed with documentation, specific examples, procedural details, while Harmon relied on broad accusations, and when confronted with evidence, he simply changed the subject. A conservative commentator jumped in. This isn't even about politics, frankly. It's about professionalism, about approaching serious topics with substance rather than sound bites. A sentiment echoed across varied outlets in ways that transcended typical partisan divides. At Georgetown Law, the impact continued to unfold. The dean's office had received dozens of emails, some from alumni expressing pride in the substantive discussion, others from prospective students impressed by the intellectual environment, though a few from donors expressed concern about Judge Harmon's treatment, a concern quickly countered by faculty who pointed out that challenging ideas was precisely what academic institutions should do. In the faculty lounge, professors debated the broader implications for legal education. We spend so much time teaching students case law and statutory interpretation, Professor Martinez observed, stirring her coffee. But yesterday was a master class in something equally important: how to maintain professional composure and factual precision under pressure. Her colleague nodded thoughtfully. Did you notice how she never took his bait, never made it personal, never responded emotionally, even when the questions were clearly designed to provoke exactly that response? Across campus in a constitutional law seminar, students were still discussing the previous day's exchange. I think what impressed me most, a young woman observed, was how thoroughly she had researched his previous positions. She knew exactly which cases to cite, which decisions would highlight the inconsistencies in his own approach. Her professor nodded approvingly. Preparation isn't just about knowing your own material. It's about understanding your audience, anticipating counterarguments, and being ready to address them with evidence. A lesson on full display yesterday. Meanwhile, in his chambers, Judge Harmon sat alone reviewing emails, his expression darkening as he scrolled through messages from colleagues, ostensibly supportive but containing thinly veiled references to the panel. He had underestimated her badly, assumed that a conservative former prosecutor would resort to political talking points when challenged on substance. He hadn't expected the meticulous documentation, the specific case citations, the detailed procedural explanations that had transformed what should have been a routine takedown into something else entirely. His clerk knocked tentatively on the open door. "Judge, the American Bar Journal is requesting comment on yesterday's Georgetown panel, specifically about Ms. Bondi's points regarding ethical standards in politically sensitive cases." Harmon waved dismissively. "No comment," he muttered, turning back to his screen where another clip was circulating, this one showing the moment when Bondi had asked if selective scrutiny wasn't itself a form of bias, a question he still had no answer for. At a downtown law firm, a hiring partner discussed the panel with associates during their lunch meeting. "I want every one of you to watch that exchange," she instructed. "Not for the politics, but for the professionalism. Notice how Bondi never let herself get pulled into the personal attacks, never adopted the accusatory tone that was being used against her. She just systematically presented evidence in a way that couldn't be dismissed. That's the kind of lawyer we need, regardless of political perspective. Across the city, similar conversations were happening in law offices, government buildings, and judicial chambers. Not about who had won or lost politically, but about the rare example of substance prevailing over spectacle in a public forum. The press secretary of a prominent senator fielded yet another call about the exchange. "Yes, the senator has seen the video," she confirmed. "No, he won't be commenting on Judge Harmon's performance. Or lack thereof," she added with a slight smile. But privately, the senator had already requested a complete review of Bondi's approach, seeing valuable lessons for his own public appearances on contentious issues. By evening news cycle, the story had evolved, moving beyond the specific exchange to broader questions about discourse, about preparation, about evidence-based dialogue in a political environment that rarely rewarded such substantive approaches. A legal podcast released an emergency episode titled "When Evidence Meets Assumption: Lessons from the Bondi-Harmon Exchange," featuring 3 law professors analyzing the specific techniques Bondi had employed not as political strategy, but as litigation approaches for contentious courtroom confrontations. "She did something trial attorneys learn early," one professor explained. "Never adopt your opponent's framing. Never let them define the terms of the discussion. When Harmon tried to make it about politics, she redirected to evidence. When he made accusations, she presented documentation. When he tried to provoke emotion, she responded with facts. It was textbook perfect execution." Back at Georgetown, a student newspaper was preparing its front page for the next day, debating headlines that would capture the unexpected impact of what had occurred. "Beyond partisan politics, a lesson in legal integrity," finally winning out. Over more sensational options, the editor explaining his choice simply, "This wasn't about who won or lost. It was about how they engaged and what that teaches us about discourse." As night fell over Washington, Pam Bondi sat in a quiet restaurant, sharing dinner with a former colleague who had attended the panel. "I still can't believe you agreed to that format," he remarked, shaking his head. "You had to know it was designed to put you on the defensive." Bondi smiled, taking a sip of water. "That's precisely why I accepted," she replied, "because sometimes the best way to change perceptions isn't through argument, but through demonstration." He raised an eyebrow curiously. "Demonstration of what exactly?" She considered this thoughtfully. "That substance can prevail over spectacle, that evidence can overcome assumption, and that the strongest position isn't the loudest or most aggressive. It's the one best supported by facts." Across town, Judge Harmon declined yet another request for comment as clips continued to circulate. His reputation not destroyed, but certainly altered by an exchange he had initiated but failed to control. What he couldn't have known, what none of them could have anticipated, was that the impact of that afternoon would extend far beyond a single panel, beyond personalities or politics, to something more fundamental about discourse itself, about approaching difficult conversations with evidence rather than accusation, with substance rather than spectacle, a lesson that would continue to resonate long after the specific details of the exchange were forgotten. The broader impact unfolded gradually in ways that transcended the initial viral moment. 3 days after the Georgetown panel, calls began coming into Pam Bondi's office, not from media outlets seeking sound bites, but from law schools across the country requesting guest lectures on legal ethics, prosecutorial discretion, and professional integrity. A week later, the American Bar Association extended an invitation for her to deliver the keynote address at their annual conference on maintaining professional standards in politically charged environments. The subject line reading simply, "Your Georgetown approach exemplifies the principles we hope to promote." Judge Harmon, meanwhile, had withdrawn from 3 upcoming panel appearances, citing scheduling conflicts, though legal observers noted the sudden changes came only after format adjustments requiring substantive responses rather than the moderated discussions he typically preferred. At Georgetown Law, something unexpected happened in Professor Martinez's legal ethics class. Students submitted a petition requesting a curriculum addition focusing specifically on evidence-based approaches to public legal discourse, citing the panel as a transformative example of how legal principles could be maintained even in politically charged environments. And the Dean's office approved the addition, recognizing its academic value beyond political considerations. In law firms across Washington, hiring partners began asking new questions during interviews with potential associates. Describe a time when you maintained professional composure under hostile questioning. How do you prepare for contentious legal discussions? Are you familiar with the Bondi approach, a new shorthand for thorough preparation and evidence-based responses to challenging situations? A senior partner at Williams & Connolly, one of DC's most prestigious firms, instructed his litigation team to study the exchange not for its politics, but for its technique, pointing out how she never gets drawn into responding emotionally, how she anticipates the next line of attack and preemptively addresses it with documentation, noting that's the difference between reacting and preparing. Legal blogs analyzed the specific methods Bondi had employed, breaking down her approach into teachable components. 1. Anticipatory preparation. 2. Evidence-based responses. 3. Redirection to substantive issues. 4. Calm maintenance of professional demeanor. 5. Strategic questioning of underlying assumptions. Techniques that transcended political alignment and were applicable across varied legal contexts. The National Association of Women Lawyers featured an analysis in their monthly journal highlighting how Bondi's approach demonstrated a path beyond the double bind many women faced in contentious legal settings, where responding forcefully is labeled emotional, while failing to respond appears weak, citing specific moments where Bondi had redirected personal attacks to substantive issues without either accepting the frame or appearing defensive. A model applicable across professional contexts. 2 weeks after the panel, a prominent law review announced a special issue devoted to evidence-based dialogue in polarized legal contexts, featuring contributions from scholars across the political spectrum, examining how substantive engagement could prevail over partisan positioning. In media interviews, Bondi consistently redirected from the personal dynamics of the exchange to the broader principles at stake. I think what resonated with people, she explained on a Sunday morning show, wasn't about personalities or politics. It was seeing that substance can still matter, that evidence can still prevail over assumption when presented clearly and systematically. And when the host pressed for details about Judge Harmon's apparent hostility, she smiled and redirected again. I think the more interesting question is how we create forums where legal issues can be discussed based on their merits rather than through political framing. Her refusal to engage in personal criticism only, reinforcing the professionalism that had characterized her approach throughout. Judge Harmon eventually issued a statement through his chambers, thanking Georgetown for the opportunity to participate in a robust discussion of important legal issues, the carefully worded message avoiding any direct reference to the exchange itself, and legal observers noted the irony of his using the same vague generalities that had proven so ineffective during the panel itself. At law schools beyond Georgetown, professors began incorporating video of the exchange into their curriculum not as a political case study, but as an example of professional advocacy, demonstrating how preparation and evidence could overcome even the most challenging environments. A third-year Harvard law student remarked in a class discussion that watching the exchange had changed her approach to moot court competitions. "I realized I was spending too much time crafting clever arguments," she admitted, "and not enough time anticipating challenges and preparing evidence-based responses." And her professors nodded, noting that the same principle applied in actual courtroom practice, where judges increasingly expected substantive evidence rather than rhetorical flourish. Perhaps the most significant long-term impact came 6 months later when the Judicial Conference announced new guidelines for judges participating in public forums and academic panels, emphasizing the importance of substantive engagement with evidence presented by all participants, regardless of political affiliation. And though the announcement didn't mention the Georgetown panel, legal observers immediately recognized the connection to what had transpired that day, later confirmed by a senior judicial ethics advisor who noted that the exchange had indeed prompted a re-evaluation of how judges approached contentious public discussions. At the annual Federalist Society convention, a panel on legal discourse featured speakers from across the political spectrum, including liberal and conservative jurists, all emphasizing the same principle, that the strength of legal reasoning should be measured by its substantive merit, not its political alignment, with a conservative judge summing it up simply, "What we witnessed in that exchange wasn't the triumph of one political view over another. It was the triumph of evidence over assertion, of preparation over presumption, principles that should transcend political differences in our profession." In state attorneys' general offices nationwide, training programs began incorporating elements of what was now commonly called the Bondi Protocol for handling politically charged investigations, focusing on transparent processes, documented decision, matrices, and evidence-based communication, regardless of political pressure from any direction. A year after the panel, Pam Bondi published a law review article titled "Beyond Politics: Evidence-Based Approaches to Legal Ethics in Polarized Environments," which quickly became required reading in professional responsibility courses at law schools across the country. The article never mentioning Judge Harmon by name, but focusing instead on systematic approaches to maintaining legal integrity amid political pressure. The Georgetown panel had faded from headlines, replaced by newer controversies and conflicts, but its impact continued in less visible but more significant ways, in how law students prepared for difficult questions, in how attorneys approached contentious hearings, in how judges considered their public engagements. The lesson that had resonated wasn't about who had won or lost a particular exchange, but about something more fundamental to the legal profession itself. The understanding that in an era of polarization, soundbites and political positioning, evidence and substantive reasoning could still prevail when presented with professional integrity and thorough preparation. As one legal commentator observed in a retrospective article, the exchange wasn't significant because it changed anyone's political views. It was significant because it reminded an entire profession of something essential that they had perhaps forgotten in the heat of partisan conflict, that the law at its best has always been about evidence, not assertion, about facts, not feelings, about substance, not spectacle, principles worth remembering regardless of political alignment.